What's the second issue?
The big issue that everybody talks about is what's called standing. This is not the right party to be filing the lawsuit. Again, that ties into verification because the verification is supposed to be done by somebody from the plaintiff, the lender. But if that's not the right party to be doing it, then the verification really it's no good.
We're putting a fox in charge of the hen house.
It's a circular argument saying
It is.
Carmen is verifying the complaint that Carmen filed because he knows it's true.
Right. That'd be like you verifying that I know the system of Coke, the Coke formula. Yeah,
How do we
work together? Obviously, he swore to it, so yeah, it's got to be true.
I watched Carmen read that from the computer, so
exactly.
it's true.
So it's got to be true.
So that's the huge
Folks,
problem.
If you think we're kidding,
cases.
and we're obviously making light of a very serious topic, but if you think we're kidding, we're not. This is the stuff that we see on a daily basis, and to tell somebody, yeah, you know, I look after they come to us. And maybe somebody's gone through the foreclosure process, and I look at the documents, sometimes I'm horrified, absolutely horrified that a person lost but they didn't fight it. And if you don't hire an attorney to fight it, you're putting yourself way behind the 8 ball, and you could be giving up valuable legal rights that you should not have given up. So what's the next thing?
Well, with standing, there are certain things that we look for. When first asked, what do you look for in the complaint?
Yes.
Standing is a huge issue. They need to somehow show that they own and hold that note, or that they are the right party to file this lawsuit.
Right.
There are certain documents that need to be attached to the complaint.
Yes.
We look for these missing documents. It doesn't mean, and folks, I want to make this really clear, because a lot of people say, oh, they don't have this document, they can't do it. They need to have the note. We know that. Everybody knows that. There are other ways, and they can file what's called a lost note count. However, again, what we know in our line of work and seeing it every day, there are certain requirements to still be able to foreclose. If they file a lost note count, there are requirements. What needs to be included? They still need the terms of the note. At some point, a note needs to be filed.
Right.
So in this, when standing becomes an issue, there are what's called endorsements of the note. That's when the note is transferred to another party. Carmen talked about it earlier. And assignments of mortgages. Much of the case law and much of the arguments about standing comes in when there's a discrepancy. The documents filed to the complaint. You're looking for defects. A defect is anything in the complaint you see that's not true. They will talk about amounts that are due and owing. Again, question these things through discovery. Look for defects in the documents attached to the complaint. Does an assignment not line up with an endorsement? Is it undated? There's case law out there now that supports a homeowner's position, which is wonderful.
Right.
That they didn't know who, at the time the complaint was filed, who should have been the party filing the complaint.
Right.
That's huge. They reversed summary judgment in that case.
Right.
So it is important to make sure, look at what's attached, but what are they missing, more importantly? Because that may be
what we don't have.
Your huge defense.
Again, there's times, folks, where we'll see a complaint, and it'll say, on the note, it'll say Countrywide. There was a Countrywide note. I got my loan from Countrywide. And then Countrywide immediately turned around, securitized it, and then put America Servicing Company as the servicer. So people think their loan was transferred from Countrywide to America Servicing Company, but America Servicing Company is only a servicer. They don't own the paper. They're just an agent for Countrywide or whoever Countrywide sold it to. Now, the problem with that is, later on, you get a complaint saying Deutsche Bank is the trustee of the securitized trust of the Seawalt Trust, and you're like, what in the world is going on here? And all of a sudden you have an endorsement, or not an endorsement, a verification from somebody at Deutsche Bank or saying, I work for the servicer, and this is all true. It's basically a quantum leap of faith that we're supposed to take. Now, the problem is, in Florida, we've got some bad case law that says as long as they allege that they own and hold the note or hold the note, then that gets you by a motion to dismiss. In other words, it gets you into the playing field, but it's not the grand slam. Right. To put it in terms that some people can understand. In other words, it just gets them into the ball game, but it doesn't mean you win the case by far. And I don't want anybody to think that just because they allege it, it's true. Most of the time, it's not.
Right, and again, I just had this come up the other day. One of the huge issues, the complaint alleged that they're the owner and or holder of the note, but there was no note attached. Now that's an easy one. that case law doesn't really apply. None of that, the bad case law, the good case law. There was simply no note. That's where it's make sure your motion to dismiss gets in. They're not getting past that unless they have that note at that point, or like I said, the lost note count. But here, when Carmen's talking about Deutsche Bank, you've never heard of Deutsche Bank, I'm sure. If you're all of a sudden getting paperwork from Deutsche Bank trustee for Seawall, yada yada, you're thinking, oh no, America's Home Mortgage Servicing is who's handling my loan, or my original loan was Countrywide. Those are the things you want to question. You want to make sure your attorney questions them through the discovery.
Right.
It is so important.